Hello mga cognizance, welcome back to my channel, and we are now in a criminal jurisdiction. So, there are three essential requisites of criminal jurisdiction, but before that, we'll discuss first of what is criminal jurisdiction. Criminal jurisdiction is defined as the power of a tribunal to hear and try an offense and impose the appropriate punishment. So as what I have mentioned, based on my previous discussion, that jurisdiction is conferred by law. It is not subject to any stipulation by the parties. Pwede lang siya may tabo to avail or to may na to nga there is or nga para dili mahitabo nga naay miscarriage of justice. But kung di ta maguna-una kinahanglan nga ang jurisdiction is conferred by law. Dili pwede magsabot-sabot mo nga ari mi mag-file diri kaso diri sa kuan kinini ang lain nga branch mingon kag ari ko sa I mean, ang imong jurisdiction is MTC. Nya, ay may ganahan sa MTC at tumig RTC. Di na pwede. Ha, di na pwede nga naman it is conferred by law. Di na pwede nga magsabot-sabot mo. Ha? Kaya nga naman, ang mahitabo na is ma-dismiss siya for want of jurisdiction. So, okay, there are three requisites of criminal jurisdiction. First, jurisdiction over the person. Ay, over the person of the accused. So, when does maka-acquire sa jurisdiction over the person of the accused? Please take note on these three essential requisites of criminal jurisdiction because it is very important as we go along with our discussion. Kay kining tulo nga criminal jurisdiction is importante ni siya. Kay kung wala ni siyang tulo, mahitabo nga ma-dismiss ang imong pag-file sa kaso. Kaya nga naman, kung wala kay jurisdiction over the person of the accused, how you can acquire that jurisdiction of the person? Nga wala maka naka-arrest. Wala nimo na walay voluntary surrender. Walay apprehension. Therefore, wala kay jurisdiction over the person of the accused. Kinahanglan importante og timan Okay? The court may acquire jurisdiction over the person of the accused in the following manner. First, upon his arrest with or without a warrant. So, ganihan, nag-discuss na mata about, nihatan na kong synopsis on arrest without a warrant and arrest with a warrant. Second, by voluntary submission of the accused, either by posting bail, filing a motion to quash, or appearing of the arraignment. So, mo na siya gitawag na to nga na ay voluntary submission of the accused. Kung pananglitan, file ka og ni-post kag bail or during arraignment is nagpakita ka dito na nay voluntary submission. Ha? But there are some cases where naghimo kag pleading diha, nagsabi kasi mong pleading, so dili siya ma-considered nga voluntary submission. So naay mga instances nga dili nimo directly ma-considered as voluntary submission. But on this case, mingon tag pagpiyansa ka, mingon tag motion to quash ka, mingon ta og ni-appear ka sa arraignment, then that is considered as voluntary submission. That pwede na ka na makakuha of jurisdiction over the person of the accused. Second, jurisdiction over the subject matter. Jurisdiction over the subject matter is the power to hear and determine the case of general class to which the proceedings in questions belong. And it is conferred by the sovereign authority, which organizes the courts and defines defines its power. Generally, jurisdiction is the right to act or the power and authority to hear and determine a cause. It is a questions of law. The term imparts the power and authority to hear and determine issues and facts of the law, the power to inquire into the facts, to apply the law, and to pronounce a judgment. Meaning to say, ang kinisiyang jurisdiction over the subject matter is ma-determine na siya nimo upon filing of the case. Ngadto sa imuhang gi-file nga kaso, upon institution of the criminal offense, maka-acquire na kag jurisdiction over the subject matter. Kung unsa na nga kaso ang imuhang gi-file, diha nato makita ang jurisdiction kung asa nimo i-file. Okay, nakuha ang jurisdiction over the subject matter. Now, lastly, we have the jurisdiction over the territory. Muna niingon ta nga venue is jurisdictional in a criminal offense. In criminal prosecutions, the action shall be instituted and tried in the court of the municipality or territory wherein the offense was committed or any one of the essential ingredients took place. Meaning, kung diin ay tabo ang kana siya nga krimen, adto na to na i-file. On cases of continuing offense or transitory crimes, ang tanan nga maagian, pwede nimo ma-file ng kaso. But don't worry because we have a separate discussion on that provided under Rule 126 of the Rules of Court on search and seizures. I-discuss na nato diha kung unsa ang mahitabo nga pwede ka dihang mo-file sa imuhang mo file or mo kuan ka kana maka-acquire kag jurisdiction over the territory. Okay, let us proceed. Hence, if any of these elements is proven to have occurred, let us say in Pasay City, the proper court in that city has jurisdiction. Meaning, nakakomit kag krimen, diri sa Pasay City. Any essential elements or ingredients in the commission of the crime is naa sa Pasay City, din pwede ka mo file og kaso sa court within Pasay City. Here is one case nga decided by the court in the case of A versus BB. So it is a case of bigamy where ang iyahang bana is nakigminyo og laing babae outside the Philippine territory. Kung ato siyang makita, going back to Article 2 of the Revised Penal Code, it is not one of those enumerated under Article 2 of the Revised Penal Code provided the extraterritorial application. Nga naama to dito. Balik ko na to as part of your review, niya ta dito, should commit an offense while on Philippine ship or airship, should counterfeit or forge any currency or any securities and obligations of the Philippine territory. And third, gi-commit siya based on the preceding paragraph which talks about the obligation and securities of the Republic of the Philippines. And fourth, should commit an offense while being a public officer in the performance of his duty. And of course, katong atong gi-mention, I mean, akong gi-discuss about sa bukto nga criminal those committed a crime against national security and law of the nation. Kung makita nato ang enumeration, is wala dihay crime of bigamy. There are some special penal laws nga maka-acquire og jurisdiction sa Pilipinas. Even if it is committed outside the Philippine territory. Say for example, on the crime of anti-terrorism, on the crime of trafficking of person, so kana siya maka-acquire tag jurisdiction ang Pilipinas even if it is committed abroad. Why? Because it is provided under that certain Republic Act. But on the case that I have been mentioned, nga ni-commit siya bigamy. Say for example, sa Singapore, nakigminyo siya dito. Meaning to say bigamy, niyo mata there was subsequent marriage committed by a person nga valid pa ang iyahang prior marriage. Now, ni-file sila kaso. Ilang gi-file og kaso o violation of Republic Act 9262 or the violation against women and their children. Question, is that case filed by the offended party? Can the Philippines acquire jurisdiction? The answer is yes. Why? Based on my discussion, naningon ta nga when we talk of criminal prosecution, venue is jurisdictional. And mayroon tag venue where the elements or any of the elements or essential ingredients of the crime took place. Kung mayroon tag violation against women and their children, asa ang biktima? The victim here is the wife. And of course, the wife is living here in the Philippine territory. Therefore, si Philippines maka-acquire og jurisdiction. Ano maka-acquire sa jurisdiction? Because any of the essential ingredients of the crime took place din nahitabo sa Pilipinas. Even though the crime of bigamy was committed outside the Philippine territory, but the issue here is not about bigamy, but the emotional abuse, the mental anguish or any psychological abuse nga gihatag sa iyahang bana nga ni-commit og pakigminyo outside the Philippine territory nga naa diri sa Pilipinas ang iyang asawa. Maka-acquire og jurisdiction. Question, unsa nimo pag-acquire og jurisdiction over the person? Maka-acquire kag jurisdiction over the person kung pananglitan mo balik na ang iyahang bana diri sa Philippine territory. Di ba naman tayo gitawag og jurisdiction over the person of the accused, mahitabo kung pananglitan, maaresto, or there is a voluntary submission. Then second, ginang gitawag na to jurisdiction over the subject matter. Unsa man imong filean og Republic Act 9262. So i-determine ngadto, yes, there is a violation because that act of the husband causes mental or emotional abuse, psychological abuse, and of course, butangan pa nato wala mag-support na economic abuse against the wife. Therefore, maheld liable siya and the Philippines can acquire jurisdiction over the crime in violation of the crime against women and their children. So, pwede na siya. That is why, very important nga atong timaan sa criminal prosecution that venue is jurisdictional. So, venue in criminal case is an essential element of jurisdiction. Hence, for jurisdiction to be acquired by a court in a criminal case, the offense should have been committed or any of its essential ingredients should have been taken place with the territorial jurisdiction of the court. It is in that court where the criminal action shall be instituted. So, I hope you understand those three essential requisites of criminal jurisdiction because those criminal jurisdiction is very important as we go along with our discussion. So, I hope you understand. Thank you and God bless us all.